Divorce is one of the most financially complex events a person can face. The decisions made during this process can shape the next chapter of a life for decades. Welcome to Advisor in Your Corner, the podcast for individuals navigating the financial realities of divorce in California, and for the attorneys, mediators, therapists, and coaches who support them. Your host is Weinberger, a certified financial planner professional and certified divorce financial analyst. Through his firm, Marriage Financial Solutions, Alex consults directly with clients on the financial side of divorce, and the firm welcomes engagements from listeners and from the professionals who serve them, bringing clarity to the questions that matter the most to you without the jargon. This is Advisor in Your Corner.
Here's something that almost nobody warns affluent couples about, even when they're spending tens of thousands of dollars a year on sophisticated estate planning. The more carefully you've structured your wealth to protect it from estate taxes, the more vulnerable you may be in a divorce. The trusts, the family limited partnerships, the GRATs and the SLATs and the QPRTs, all of those elegant tax planning vehicles you set up over the years, they were designed to protect your family's wealth from the IRS. They were not designed to be unwound under the time pressure of a divorce, and unwinding them often comes with consequences nobody anticipated when the plan was being built. There's a phrase I heard recently from a high net worth divorce attorney that I haven't been able to stop thinking about. He said estate planning at the very top end is what he calls estate planning 2.0 or 3.0. Sophisticated, layered, multi-entity, designed to last for generations. When divorce hits, the question becomes, how do we separate them? What are the tax consequences as a result of separating or blowing apart that estate plan? That phrase, blowing apart, is the right one. Today we're talking about what actually happens when carefully constructed estate plans collide with a divorce, why the most expensive mistakes in high net worth divorce happen in this category, and what to know if any of these vehicles are part of your own picture. We'll cover 5 things. First, why high net worth couples have these elaborate structures in the first place. Second, what happens to revocable trusts and joint living trusts when a marriage ends. Third, the irrevocable trust problem, which is where things get genuinely complicated. Fourth, the specific vehicles that cause the most divorce friction, SLATs in particular. And fifth, how to approach the unwinding process if you find yourself there. Let's get into it. Couples with significant wealth don't just open a brokerage account and call it a day. By the time a family has accumulated, say, 10 or 20 or $50 million in net worth, the financial structure they're sitting on usually includes a layered set of vehicles designed to do 3 things. Reduce estate taxes that would otherwise apply to their estate, protect assets from creditors and lawsuits, and transfer wealth to children and grandchildren in a controlled, tax-efficient way. These vehicles have names that sound like alphabet soup: revocable living trusts, irrevocable life insurance trusts, often called ILITs, grantor retained annuity trusts or GRATs, spousal lifetime access trusts or SLATs, qualified personal residence trusts or QPRTs, dynasty trusts, family limited partnerships, family limited liability companies. The list goes on. Each of these vehicles has a legitimate purpose. Each is the product of careful planning by estate attorneys, CPAs, and wealth advisors working together. And each was almost certainly built without divorce as the primary concern. That last point is the one that catches people off guard. Estate planners are paid to think about death, taxes, and asset protection from third parties. They are not paid to think about what happens when the 2 people at the center of the plan stop being a couple. When that happens, the structures often have to be unwound, repositioned, or worked around. And the unwinding process is where the surprises live. Let me start with the simpler case: revocable living trusts and joint living trusts. Most affluent couples have a revocable living trust as the foundation of their estate plan. It typically holds the home, the brokerage accounts, sometimes the business interests, and other major assets. The trust is revocable, which means either spouse or both, jointly depending on the structure, can change it. amend it, or dissolve it at any time. It's effectively a wrapper around the assets, designed primarily to avoid probate and provide for orderly succession. In a divorce, a revocable living trust gets dissolved or restructured. The assets inside it are still subject to division according to whether they're marital or separate property. The trust itself doesn't really protect anything from the divorce. It's the underlying ownership of the assets that matters, and that gets determined under family law rules, not trust rules. The mechanics of unwinding the trust are usually manageable. The bigger conversation is just about what assets get allocated to whom. The irrevocable trust problem is fundamentally different. An irrevocable trust, by design, cannot be revoked or modified by the person who created it. That's the whole point. The grantor gives up control of the assets in exchange for the assets being legally separated from their estate, which provides tax benefits and creditor protection. In a divorce, this creates a question that's much harder to answer cleanly. If the trust assets are no longer owned by the grantor in any meaningful sense, are they marital property? If the trust was created during the marriage and funded with marital assets, can the non-grantor spouse claim a share? Does it matter if the spouse was a named beneficiary? Does it matter if the trust was created in a state with favorable trust laws? Does it matter if the family relied on distributions from the trust to fund their lifestyle? The honest answer is it depends, and the analysis is intricate. Different states have come to different conclusions. There are cases where irrevocable trusts have been protected entirely from divorce claims, and there are cases where courts have effectively unwound them or treated them as part of the marital estate. There are also cases in between, where the trust assets weren't directly divided, but the existence of the trust was considered when allocating other assets. A family law attorney experienced in your state's case, law on trusts, is essential here. So is the estate attorney who built the structure in the first place. They need to be talking to each other, and they need to be talking to a certified divorce financial analyst who can model the financial consequences of different approaches. Let me spend a moment on one specific vehicle that has caused more divorce friction in recent years than almost any other. The Spousal Lifetime Access Trust, or SLAT. A SLAT is an irrevocable trust that one spouse creates for the benefit of the other. The grantor spouse, often the higher earning one, transfers assets into the trust. The beneficiary spouse can receive distributions during their lifetime. After the beneficiary spouse passes, the remainder typically goes to the children or grandchildren. The structure is popular because it removes assets from the grantor's estate for tax purposes, while still allowing the family to indirectly access those assets through distributions to the beneficiary spouse. The structure works beautifully as long as the couple stays married. The grantor spouse no longer owns the assets, but the beneficiary spouse can still draw from them, so the household effectively retains access. The estate tax exclusion has been used. Everyone is happy. The problem with SLATs in divorce is straightforward. The grantor spouse irrevocably gave the assets to a trust for the benefit of the other spouse. The grantor cannot get those assets back. The beneficiary spouse, who is now the soon-to-be former spouse, is the one entitled to distributions for the rest of their life. I've seen cases involving SLATs where the grantor spouse spent 6 and 7 figures on legal work, trying to argue that the divorce should somehow undo the trust, that the original intent had been a joint family vehicle, that the assets should be brought back into the marital estate. Sometimes those arguments succeed in part. Often they don't, or they succeed only with substantial settlement offsets in other categories. The SLAT was designed not to be undone, and it works as designed even in this scenario, which is exactly the problem. If you and your spouse have a SLAT and you're contemplating divorce, please understand that the conversation about it needs to happen early, with the right attorneys, before any decisions are locked in. This is a category where good professional advice is not optional. A similar dynamic plays out with other irrevocable vehicles. Dynasty trusts, designed to last for generations and skip estate tax at each generation, are extremely hard to unwind. Grantor retained annuity trusts, which are time limited, may or may not be active during the divorce timeline, and the answer changes the conversation significantly. Family limited partnerships and LLCs that hold business interests or real estate often have buy-sell provisions and valuation discount structures that interact in complicated ways with divorce asset division. I want to spend a moment on the family business case because it's where I see the biggest dollar consequences. Many high net worth families hold their primary asset, a closely held business, inside a family limited partnership or LLC. The structure provides liability protection, allows for valuation discounts at gift and estate tax time, and gives the family centralized governance over the business. The structure also creates a real complication in divorce. Names and identifying details have been changed for client privacy. Imagine a couple. Call them Robert and Elizabeth, married 28 years. Robert had inherited a family business from his father and grown it substantially during the marriage. The business was held inside a family limited partnership where Robert owned the general partner interest and a majority of the limited partner units, with smaller interests held by his siblings and adult children. The partnership had buy-sell provisions, transfer restrictions, and a valuation methodology specified in its operating agreement. When the divorce began, the question of how to value Elizabeth's share of the marital interest in the business became deeply complicated. The valuation methodology in the partnership agreement applied at certain valuation discounts. The discounts were appropriate for estate tax planning and arm's length transactions, but they had the effect of significantly reducing the value used for divorce purposes if applied directly. Family law in their state took a different view of valuation discounts in divorce than estate tax law did. The two frameworks were not consistent. The case took 18 months to resolve, with 3 valuation experts, 2 estate attorneys, 2 family law attorneys, and a CPA all involved. The settlement that eventually emerged was the product of all of those professionals working through the conflict between the estate planning framework and the divorce framework. There was no clean answer. There was only the answer the team built together. So how should you approach the unwinding process if you find yourself there? A few things matter. The first is the team. A high net worth divorce involving sophisticated estate structures requires more than a family law attorney. You need the estate attorney who designed the structure, ideally the original one if possible. You need a CPA who specializes in trust and estate taxation because the tax consequences of different unwinding approaches vary enormously. You need a forensic accountant or business valuation expert if business interests or partnership interests are in play. And you need a certified divorce financial analyst to tie the financial picture together across all of these professionals. The second is timing. The unwinding work cannot be rushed. The structures were built over years. The decisions about how to address them in a divorce settlement have multi-decade consequences. Settlements that move quickly because one or both spouses want closure are often the settlements where these vehicles get handled poorly. The third is documentation. Every original trust document, every amendment, every funding transaction, every distribution history, every tax filing related to the structures. All of it needs to be assembled. The professionals you bring in cannot give you good advice without seeing the full picture. The fourth, and perhaps most important, is honesty about what's recoverable and what isn't. Some of these structures were genuinely designed not to be undone. Trying to undo them anyway is sometimes the right strategy, and sometimes it is throwing money down a hole. A good team will tell you which is which. There's one more thing I want to name before we close, and it's about the role of the children and grandchildren in this conversation. Many of these sophisticated structures were built with the next generation in mind. Dynasty trusts, generation skipping trusts, family limited partnerships with units gifted to children over time. The divorce conversation in those families is not just about the two spouses. It's about the broader family system. The children may have their own interests in the partnerships. The grandchildren may be remainder beneficiaries in the trusts. The estate plan reflects a multi-generational design. In those cases, the divorce settlement can affect not only the two divorcing spouses, but the inheritance and economic position of children and grandchildren who had nothing to do with the marriage ending. Settlements that fail to consider this dimension can create unintended consequences that play out over decades. The best teams hold the entire family system in view during the settlement conversation, not just the two people whose names are on the divorce filing. There's a related vehicle I want to mention briefly because it surfaces often in these cases and it's frequently overlooked. The Irrevocable Life Insurance Trust, or ILIT. An ILIT is a trust that owns a life insurance policy on the grantor. The death benefit, when it pays out, passes to the trust beneficiaries free of estate tax. ILITs are extremely common in high net worth estate plans, particularly for couples with large estates who want to provide liquidity to pay estate taxes when they die. In a divorce, the ILIT becomes a curious question. The policy is still in force. The premiums continue to be due. The former spouse may still be a beneficiary, depending on how the trust was structured. The grantor's death will still trigger the death benefit, paid out according to the trust terms. The asset is a policy, but the policy is held by an irrevocable trust, so it can't simply be cashed out and divided. The mechanics of how an ILIT gets handled in a divorce vary by the trust language, the state, and the case. Sometimes the trust can be modified by agreement of all the parties involved. Sometimes it can't, and the divorce settlement has to work around it. Sometimes the premium obligations become a negotiation point on their own. The conversations are detailed, they involve the original trust document, and they're another place where the estate attorney and the family law attorney have to be talking to each other. One last point I want to make is about postnuptial agreements. Some couples, when they realize that their sophisticated estate planning is now creating divorce complications they hadn't anticipated, ask whether a postnuptial agreement can fix the problem. The answer depends on the state, the timing, and the specifics. And it's a conversation for your family law attorney. But it's worth raising as a possibility if the divorce conversation is still in the contemplation phase and not yet in active litigation. A well-structured postnup, done with full disclosure and independent counsel for both spouses, can sometimes resolve the most contentious estate planning interactions before they become contested. Here's the thing I want you to take away from today. The estate planning that has served your family well for decades doesn't stop being important when a divorce begins. It just changes character. The vehicles that were designed to protect wealth from the IRS now have to be navigated under family law rules in a setting they were not built for. The work is doable. It just requires the right team, the right time, and a clear-eyed view of what you're dealing with. If you and your spouse have a sophisticated estate plan and divorce is becoming a possibility, please reach out before any decisions are made. The conversations that happen at this stage shape outcomes for the rest of your life and for the lives of the children and grandchildren the plan was originally built for.
Thank you for listening to Advisor in Your Corner. If today's conversation raised questions about your own situation or a client's, Alex Weinberger and the team at Marriage Financial Solutions are available to help. They work directly with individuals navigating divorce and alongside the attorneys, mediators, therapists, and coaches who support them. Every engagement is handled with the discretion, rigor, and independence the moment calls for. To learn more or get in touch, visit marriagefinancial.com. If this podcast has been useful to you, please share it with someone who could benefit and subscribe wherever you listen. This has been Advisor in Your Corner. We'll see you next episode.
The information and opinions presented in this podcast, including the views of guests not affiliated with Marriage Financial Solutions, is for general informational and educational purposes only and should not be considered personalized financial, tax, or legal advice. Marriage Financial Solutions does not provide advice regarding securities or the advisability of investing in securities. Marriage Financial Solutions is affiliated with Weinberger Asset Management, an SEC-registered investment advisor, and may refer listeners to Weinberger Asset Management when investment advisory services are appropriate. However, individuals are not obligated to use the services of Weinberger Asset Management